We cordially invite our members for today's webinar. And without wasting much time, I request our National President, CAK Suresh sir, to give the welcome address. And on the topic, the concerns of the members, we have received so many. So it's a very important webinar. We are already on live. So I request Suresh sir to please give your welcome address, sir.
Yeah, thank you, Prasad ji. Good evening to all members and today's guest speaker, Mr. Ravi Ramaiya of Secmark. You know very well that there was a case in Supreme Court. The offshoot of that particular case resulted that the mandatory compliance by the regulatory entities with respect to the disabled persons. So SEBI, it is not the brainchild of SEBI, but this is an offshoot of a court case, Supreme Court case actually. So this act actually came much earlier, proclaimed by SEBI on the basis of Supreme Court direction. But many of us missed the rather flashing of that particular requirement. Then again, when SEBI pointed out, then only everybody thought how to do what to do. Because the act, rather the circular seems to be very flat and very simple, plain vanilla. But the implication are phenomenal and it's not that easy to comply with. So with that background only, ANMI, as a part of a knowledge series, arranged today's webinar. And the chief speaker is Mr. Ravi Ramaiya of Secmark. He will present the whole matter in his own style. And we are also having with us officials from NSEIL and CDSL to give you rather to answer your queries, if any, with regard to the implementation of the said requirement, pronounced by the SEBI because of the Supreme Court direction. With these few words, I am leaving the floor to Mr. Ravi Ramaiya to take forward, sir. Please, sir.
Yeah. Thank you very much, Suresh, sir. And thank you very much, ANMI, for allowing this opportunity to me and Secmark Consultancy Limited to have a session on the rights of disabled persons on accessing the information technology platforms that are developed. It applies to both government developed platforms as well as the privately developed platforms. So all of us, we are falling under those privately developed platforms. The core reason for the enaction of this act is that, see, in India, in foreign countries, those who have visited, they would see they are so cautious about the rights of people who are disabled. So they will have separate gangways, accessibility models. They will have wheelchair facility, even the washrooms, the drinking water, everything is accessible. Likewise, many of the countries have also worked very hard and made it more convenient. You cannot say equally convenient to all, but as far as possible, the disabled persons are also able to access the digital platforms. And this is coming through UN General Assembly resolution, to which India is also a part, and consequent to that, the act was passed in 2016. The implementation of this act has more taken up by the government, but it was not very much actively pursued by the private sector. And as a result, certain public interest litigations were filed. And in April 2025, a judgment has been passed by the Supreme Court in this regard that the implementation may kindly be done at the earliest. Now, see, it is a royal way, it's a direction from Supreme Court, so all the regulators will have to fall in. And this will not just apply to us, it will apply to all facilities, not financial markets, like even the telecom vendors. Everything falls under private establishment. So there are definitions which we will go through to whom it will apply, and it will apply to all walks of life, all simple things. In fact, our industry is one of the least accessed industry by disabled people, but generally, like taking a mobile SIM, for that they have to do a KYC. It will apply to that as well. So this is a very vast applicability and vast repercussions on the entire way in which people have worked so far. So with this, I think we can start off with the directly go to the SEBI circular requirements and all that. So I have a short PPT which has been done. I tried to keep it short, but it has become a bit long. But I will keep as brief as possible, and we will access the SEBI circular and other documents as and when required for the presentation. Sir, is my window visible to everybody?
Yes,
Yes.
yes.
Yeah. So today we are having a session on the Rights of Persons with Disabilities Act 2016 and rules made thereunder, which have been mandated by SEBI. So SEBI has issued a circular. In detail, we will discuss the entire circular and also the requirements under various regulatory guidelines. So first, let us see what is the goal of this session. So every time, whenever we start off, we should always know what is the goal of this session. First and the foremost goal is the understanding the requirements of the SEBI circular dated 31/7/2025, which deals with rights of the Persons with Disabilities Act 2016 and its implementation. Discuss the possible actions that we can take as regulated entities. Now, regulated entities not does not just include stockbrokers or SEBI registered intermediaries. It also includes MIs. So whatever we are discussing right now will be equally necessary for everyone to implement, including MIs. Um, if we see the definition in the Act, same level of modification may be required even by SEBI because it will fall under government establishment. So everybody, every market participant, right from the regulator, the MIIs, and the intermediaries, have to work on this requirement and ensure compliance with all the requirements that are specified in the Act rules and the references that are made therein. Third is we will also discuss the difficulties, if any. To frankly tell you, when I read the guidelines which are required for implementation, I think those guidelines are very, very important and simple to implement with little discipline. And therefore, I added the word if any. When we read that one small document which I have downloaded, how it is to be written in a digitally accessible format. So it is very simple. After reading that document, I could make out, and it requires little discipline on our programmer's part and the document generation part. Rest everything will automatically follow. So these are the two circulars. As Suresh sir said, there is an extension as well. So there is a um, first is the main circular which has been issued on July 31, 2025, which will be our main agenda of discussion. Second is the extension circular which has come just a few minutes back or maybe an hour back, where all the deadlines under this circular have been extended. So first, let us okay, let us first see the deadlines because I think that will be more of an interest. I will go back one more slide once again. So these are the latest dates which are applicable. So September 30, 2025 is the submit of list of all digital platforms that registered intermediaries have. And same with the same date, we have to also submit a compliance or action taken report. So what compliances are to be done in that? First and the foremost is appointment of nodal officer and all that I will explain. But at least that compliance which is required to be done immediately, that has to be completed. Appointment of nodal officer and defining roles and responsibilities. Maybe the MIS will give you a link for allowing you to report who is the nodal officer under this act. So those things at least we should do, and rest inventory we can keep that we will comply as per the deadlines. Third is the December 14, 2025, which is for appointment of an auditor who is empaneled with International Association for Accessibility Professional. Now, this is a separate body where audit firms can empanel themselves, and those auditors have to are the only eligible auditors who will certify whether the platforms that are there for a registered entity are in line with the requirements or no. Then conduct of accessibility audit will have to be done by April 30th. So 6 months time has been given. I think December to April. So good amount of time has been given for auditors to audit. Post that the recommendation of the auditor have to be implemented within further 3 months, that is July 31, 2026. And thereafter, annual audit reports will have to be submitted from 30th April 2027 and thereafter. So I believe it will be for the financial year ending March 27, and first reports deadline as per the circular appears to be 30th April 27. So these are very liberal deadlines, and though the compliances are many, these are practicable and liberal deadlines which all of us we should endeavor to try and meet. Now let us go one slide behind. Let us now see what is the main content of the circular. So it intends to provide access to digital platforms of registered entities to persons with disabilities. We will see what is the definition of persons with disabilities and all that, how it has to be given and all. Now there are 4 sections which have been specifically mentioned, sections or rule, which have been specifically mentioned in the circular. There was actually not too much of a necessity for carving out these, because these are not making too much of a sense without reading the entire act. Now, when you come to the relevant section of accessibility, you will note that the accessibility does not mean accessibility by a disabled person. It says government should form a rule for allowing accessibility. Now, Section 40 therefore does not have any bearing on the registered entities. It is for the government to make rules, which it has already done. But I believe while writing the circular, maybe they have just seen the side notes of the circular and copied this. So there will be certain things which we can ignore in the circular. It will come follow. Then Annexure 1 is the main operative part of the circular as to what is to be specifically done by the registered entities, and then there are periodical updates to be submitted, milestone based updates. We have just seen how those have been extended, and these are the extended deadlines which I am showing. So don't think that there is further extension after this. These are the extended deadlines. Now let us quickly go to Annexure 1, which is the operative part of the circular. Now, a background has been set up which says that it is an offshoot of a Supreme Court judgment that this circular has been issued. Then it says what all has to be complied. Now, Web Content Accessibility Guidelines WCAG 2.1 or latest version which may follow. Now, these are the international guidelines which are given. Now, next is the accessibility guidelines as described in the latest version of the guidelines of Indian government website. So, Indian government website guidelines is a very beautiful guideline which has been given by SEBI. It includes everything that a government body is required to do, including cyber security, development process, system development, life cycle, everything. In that, there is one small portion which is not even means which is running into 3 pages, which is on the accessibility. So only that those 3 pages are to be referred for this compliance, not the entire guideline of Indian government for website development. Then there is Indian Standard 17802, which is on the accessibility. Now, all these requirements are quite overlapping because see, everything has fallen down from the UN General Assembly resolution for allowing equal platform for accessibility for persons with disability. Now, the fourth one is the provisions of the Rights of Person Disability Act and the corresponding rules. So these rules and acts are to be complied with, but all the requirements, in fact, are overlapping, and therefore, once we have done a standardization of our website and online platforms, I think the job should be done, and very good help will be there from the auditors as well. So they will have to certify. So before final certification, they are allowed a good time to issue a report, and 3 months are there for ensuring compliance. So guidelines that way are reasonable. Timelines are also reasonable, and this will promote uniform access to everybody. Annexure 1 to the circular will continue for multiple slides. So I will drop the heading, reading the heading every time. First requirement is appointment of nodal officer to ensure digital accessibility compliance, and that person will be the contact point of SEBI for any compliance related issues or any queries from SEBI with regards to digital accessibility. Digital accessibility in short means only digital accessibility for disabled. We are not discussing digital accessibility for those who are not disabled. For this PPT, please interpret digital accessibility as only with regards to disabled persons. Now, in absence of nodal officer, the compliance officer shall be the deemed nodal officer. So, compliance officer should ideally, by this requirement, be separate. And if at all there is a situation that nodal officer is not available or he is absent or maybe he has resigned and no replacement has been done, in such case, compliance officer should be the deemed nodal officer. Please do not mistake this requirement to say that, okay, compliance officer itself is nodal officer and we will go ahead. Because very specifically it has said in absence of nodal officer. So there is a separate person nodal officer, separate person compliance officer. There has to be a grievance redressal mechanism specifically to accessibility issues shall be institutionalized with the RE. Now this is one is grievance redressal mechanism at the RE's end. I believe this has a very long-term implication and broader implication because exchanges, ODR platform, SEBI score, everything will have to be in line with this. See, the moment we start including different categories of differently abled person in this market, we will also have to protect their rights. So everybody will have to put his foot forward, including the MIS, the regulated entities as well as SEBI, to provide them equal capability of access to grievance redressal mechanism of SEBI as well. Then reporting of compliance with respect to this circular shall be done by the research entities. In our case, brokers are required to report to exchanges and depository participants are required to report to depositories. Now, quickly we will summarize what these four I have given reference. These are the four documents the platform should comply with, and 1, 2, 3, 4. Quickly we will see one slide as to what it contains. So web and document accessibility. Now Indian Sign Language, that is videos. If you know, for those who are voice and hearing audibility impaired, for them there are sign languages. Now those sign languages have to be a part of the videos. There has to be a captioning because see, someone may not be able to listen. So at least he should be able to read. So captioning has to be there. Descriptive audio has to be there. Alternative text and images are to be made available so that people can visualize things and get the desired output. And there has to be one more thing. There has to be a facility for pause and reverse in all videos. See, because disability does not mean simply hearing impairment or speaking impairment or visual impairment. There are many neurological or slow learning kind of disabilities. So there are guidelines which will be there. But in short, if we see videos which are there, those should have feature of pause, replay, and going few seconds backwards, like you have generally in YouTube. So such kind of videos to be given along with caption, and maybe at the right side bottom you can give the sign language video also parallelly running. And then the RE shall follow the PDF techniques. Now, these PDF techniques, no, these are very simple standardized techniques. These are applicable not just for PDF, these are applicable for Word also. It starts from giving a title to the document, then applying header tags, H1, H2, H3, H4. So people who have used Word extensively or people who are in programming or website development, they know what these tags are. So title tag will be there, then H1, H2, H3 will be there, then there will be paragraph marks, then there will be divs for table. So all those things are there, which is if a document is drafted or maintained in a very standard format, it will automatically comply with the requirements. So standardization and discipline has to be brought in the reports that are generated from various softwares. Then it will also require a OCR and reading capability of PDF documents. So machines can read PDF. So you have to also define the flow of reading. Now let us say you have a 2-column PDF. If after title right side column starts, the software starts reading the right side column, it will not be right because one who can see, he will read from the left. But if that order has not been specified correctly, The document may be read by the machine in a very random manner. So those disciplines are to be maintained, and automatically our compliance with these requirements will fall in place. So guidelines are very simple and very logical, in fact. Then there have to be training modules. Now, this is something which we will have to all work upon, that our general staff will have to be trained on these requirements and how they should deal with persons with disability, so that they do not end up giving some random information in any aapka to nahi hoga types. And they have to be trained. You keep a record of training that you have done to your employees, have some web sessions, and keep a record. Now let us go to registration and EKYC requirements. Now this is specifically given. So here it says digital EKYC video KYC process, including alternatives to accommodate differently abled user clients. For example, human assisted video KYC. Now you may have human assisted video KYC, which is one. Even better is if you have branches, you can send a person to such person's office rather than even having a human assisted video KYC. So that makes the life little more convenient for the differently abled people. Then allowing scanned documents upload. Now this facility is already there, so not too much of a work is to be done here. Or voice assisted KYC. Now this will be for visually impaired. So those who cannot see, for them, voice assisted KYC is one. If they have to read the documents, then it has to be in braille. But then voice assisted, if it is there, I think it will meet the requirement. So once you have done the PDF and all the web pages in a proper order, automatically it gets converted. Many news channels also, if you see the news, there is a button for readout. So if you write in that format, they are neatly written and sequence of reading is mentioned. So that way, if you do very ready-made, easy, simple tools will ensure that you are fully compliant. Then KYC and client registration forms shall include mandatory fields to indicate disability. Now, this will mandate change in our KYC requirement. You have multiple fields like net worth, income, whether you have been prosecuted by SEBI, any other regulator. Like that, you will have to add these fields, whether you are suffering from any disability. And then there is a, you can also take what is the degree of disability, because they get certificates, how much 40, more than 40% is beyond a basic benchmark. So if more than 40% disability is there, then you need to take more care of such people while discussing or while providing service. So all those things will have to be incorporated in the KYC. So two fields in KYC, one is whether you are disabled, yes or no. If disabled, what is the disability? Third is what is the degree of disability. Any application of a client with disability shall be rejected by the RE only after review of designated human officer. So in our current platforms, there are direct rejections of so many people. Like if someone is debarred by SEBI, directly reject. Don't even bother. Nobody sees that KYC. Simply the entire workflow itself rejects if it is someone debarred by SEBI and you have those controls. But here, if that person is disabled and his name is there in persons debarred by SEBI, then also it will have to be dealt with designated human officer, because there is no exception carved out. Here, we will have to change our process. The moment the workflow may, in the EKYC, if a person says that, yes, I am disabled, and he gives the details of disability, your automated rejection process cannot work. It will have to go through a human officer. Now, as all kinds of requirements keep on getting added to the registered intermediaries, maybe the broking compliance, DP compliance, systems audit, terms of reference for information security, everywhere there are audit requirements. Likewise, here also there is an audit requirement. And all REs we shall initiate a comprehensive accessibility audit of their digital platforms, including websites, mobile apps, portals, through International Association of Accessibility Professionals. This is like there is a ISACA, which is a body which is for systems auditor, or CSAS. This is another body which is managing means members of which are allowed to audit the requirements compliance with this circular. Based on the audit findings, the regulated entity shall prepare an implementation plan, and now we know that 3 months time has been given to us for implementing these observations. Existing digital platforms will have to be upgraded to meet the accessibility standards. So this is a standardization of websites that have not been made in a very standard model. I believe almost all websites will have sufferings as of now because this requirement was earlier never applicable. And all REs shall conduct annual accessibility audit. So this will start from April 30, 2027, which we have just now seen. Now let us go to, this is all about the SEBI circular. Quickly, let us go to what is the time. Sir, we have time, no? Prasad sir?
Yes, please go ahead.
Yes, sir.
Yeah. So what I have tried is I have touched upon all the four guidelines that have been given as to what it contains. See, these are very elaborate guidelines which I have studied in depth, but I will not be in a position to explain everything. So quickly we will run through what are these guidelines. So first and the foremost guideline which SEBI has said we should comply with is the Web Content Accessibility Guidelines WCAG 2.1, which has been recently released. Earlier it was only version 2. So it deals with what? So it defines how to make web content more accessible to people with disability. Now here you will see what kinds of disabilities are there. So this is a very good learning for us as to what all we should focus on. One is visual, second is auditory, third is speech, means पहला देखने का, दूसरा सुनने का, तीसरा बोलने का, चौथा physical. Physical means limbs, backbone, any part of the body if it is physically damaged. So first three are also a part. Now if eye has been injured, he is physically damaged also, plus he cannot see. So that way. Then cognitive. Now cognitive, I have whatever I was required to search in Google for myself, I have tried to incorporate the meaning. So cognitive is a condition that affects mental tasks such as learning, memory, or focus. Now for this, we should have those videos with pause, stop, slow read button. Now language disability is an inability to compose their thoughts into sentences. So these people, though they may be able to understand, they may not be able to formulate sentences. Then next one is learning ability. Now I don't know how far this will apply because see, under the Contract Act, a contract which is not done with a sane person may not, means is not a valid contract. So a person with learning ability, I think for this we will have to take some expert guidance whether such people can are falling under the people with whom we cannot enter contract, or there are certain different types of learning disabilities also where person may be eligible to enter into contract. So this is a area which I am also not very sure. Then there are neurological disorders, which is self-explanatory that it is problem of nerves, which may be brain, spinal cord, or any other nerve for that matter. And although these guidelines cover a wide range of issues, they are not able to address the needs of people with all types and degrees of combinations of disability. Now, this is a part of the WCAG 2.1 itself. So, it is an appreciated fact that this is an endeavor to facilitate as much as practically possible, but it does not ensure that entire accessibility is available to all kinds of people with all degrees of disability. Now let us quickly go to accessibility guidelines of Indian government websites. Now this is a very comprehensive guideline which I have already said. It covers everything right from website development, cyber security, everything. And there is one small chapter on page 25, 25, 26 and 27, but 25 is half and 27 is half. So effectively 2 pages. So those guidelines I have quickly carved out. Web accessibility means that the people with disability are not perceived under can also perceive, understand, navigate, and interact with the web. So this is not just reading; they should be able to interact with web. It means they should be able to do their KYC. They should be able to place orders and all such kind of things. Now, one more clarity, and we can take from SEBI that see, if in case where customers with internet trading access are not able to place orders because of any reason, maybe they don't have internet, our internet is down, then you have a call center. So whether that call center will be sufficient to meet the requirements of those who are not able to see, that is visually impaired people. So in my limited understanding, yes, the call center for buy and sell of transactions and giving information may be adequate in this case, but then that clarification will have to be taken from SEBI. Next is it encompasses all disabilities that affect the access to the web. So in web does includes apps also. So don't treat web as website, it includes mobile app, including visual, auditory, physical, speech, cognitive, neurological disabilities. We have already seen what are these kind of disabilities. And accessible by all people, whether may whatever may be their hardware, software, language, culture, location, or physical and mental ability. Now, see here, the guideline itself was not with an intention of only meeting the requirements of accessible or disabled person. It also says multiple languages, multiple cultures, multiple locations. So this also clarification will have to be taken from SEBI that whether all softwares we should have multiple languages. So accessibility guideline is actually not limited to only the disabled people. It has a very vast application. So this clarification needs to be taken by ANMI. Now, same guideline of government, it also draws our attention that if we don't comply with the accessibility guidelines, what all risk we run. So you can read those. Those are just copy paste which I have done from there, but it gives us the importance of why this accessibility guideline is important. Then let us quickly go to the Rights of a Person with Disability Act and rules. Now this is the main act and the rule that is required to be complied with. So here most important is establishment includes government establishment and private establishment. And private establishment means a company, firm, cooperative or other society association. So it applies to us. Very short point is it applies to us. Now, SEBI specified requirements. If you remember, we have seen that section 40, section 42, then one more section 46, and then there is a rule 15. So we are quickly going through those four because those are specifically highlighted by SEBI. So as I said, accessibility is on government's power to make rules. So it does not need to apply to REs, but it has come. Section 42 is on the access of information and communication technology. The appropriate government shall take measures to ensure. Now, see, government to take measures is the section. But then what measures are they going to take? All contents available in audio, print, electronic media are in accessible format. Now, this, of course, this is the main spirit of what we want to implement. Persons with disability have access to electronic media by providing audio description, sign language, same thing what we have seen earlier. So requirements are repetitive and under different acts, but those are very small in number and it can be easily achieved. Electronic goods and equipment which are meant to be used. This is about physical goods like mobile phones or everything. So those have to be as per the universally accepted design. So this does not apply. So small 3 of subsection small 3 of section 42 does not apply to us. Then let us come to 46. So time limit for accessibility service provider. The service provider, whether government or a private, shall provide services in accordance with the rules on accessibility formulated by the central government under section 40. Now see, section 40 is for rule forming within a period of 2 years from the date of notification of such rules. Now that 2 years deadline has already elapsed. Provided that this is a proviso, we need not go into. Now coming to the specific rule which has been quoted in the SEBI circular. So that is one of the most important points to touch upon. So rights of persons with disability rules 2017. So it should have been implemented within 2 years. That is by 2019. We are in 2025. So 6 years have already elapsed. Rule for accessibility rule for every establishment shall comply with the following standards relating to physical environment, transport and information and communication technology. For us, this last portion of information communication technology is relevant. Rest all we can simply draw. A standard for public buildings. Now this does not apply. A standard for bus code. This also does not apply. C is what is very relevant. Information and communication technology. So website standards as specified in the guidelines of Indian government website. Now same requirement has been quoted here. So very simple, same thing is to be complied. It has been written at 10 places, and therefore we are having an impression that we have to do too much of a thing. It is actually not. Then documents to be placed on the website shall be in electronic publication, EPUB, or optical character recognition based PDF format, and so that it becomes machine readable. Because both these kind of documents are machine readable, therefore these have to be kept in these formats. Now, provided there is a proviso, we can drop that. And second is the respective ministries and departments shall ensure compliance. Now, this is what has been bestowed as a responsibility on the government itself. So, by this, we are broadly covering what all is required under this SEBI circular, along with a short brush of all the other acts, rules, regulations, and international guidelines which are applicable. So I have tried to add everything that is possible. Now, quickly, I would like to share one last thing, which is a Word document. Um, I will show you why. And when I have said it is very simple, how did I reach to that view that it is little simple? We will quickly see that. See, this is a document published by Microsoft on accessibility document example. Very, very simple. It has complete definition. If you convert this into PDF and ask the machine to read, it will read properly. The content will also be read left to right. Means from top to bottom up to the content list, and then it will go to the right side. Then if you see here, see this is the title of the document or the H1 tag. Now where will you get it from? Just open it. See if you can see here, this is H1 heading 1. So this is the H1 tag which has been applied to this. All other headings will be second most important, and therefore they will be under H2 or subsequent. Like this one is heading 2. So rather than typing and making it bold and underline, we should use these tags in the word which are ready-made given for our report generation or document generation, and automatically our things will fall in place. Now, accessibility checker. Quickly, let us see how it works. We will see here how this is again H2. Same way, entire document has been very beautifully done. What is title? How styles are to be used. This is a very beautiful document which has been drafted, which will help us generating our reports in the formats that are required. So paragraphs, what are there, list, what is to be done, how colors are to be used. That is also specified. So very, very simple document. It only requires discipline while drafting the document and using the proper features of the word rather than Control B and Control I for bold and italics. So this also I will share with Dr. Prasad, and he will circulate it to all the audience and anybody for that matter. Another thing, if I have to share. See, I will be sharing. One is the judgment of the Supreme Court. Second is the SEBI circular, extension circular. Then this document which we recently saw, this PPT, and the guidelines which are applicable. So accessibility guidelines, then the government guidelines for website, IS 17108, acts and rules. I think I have covered all documents. Just in case, Prasad sir, you want anything more from me, no, you can please let me know. I will share that as
Yeah,
well.
I think Ravi, thanks a lot. I think we always expect ABC, but you come out always with the newest features, what are all available and also helpful to our members. That is A to Z you covered today. I am very thankful to you. And also the kind of clarity you brought to the subject, which was totally a point of complex subject because of the different paths which our members were required to search to bring the clarity. You brought it in a half an hour PPT, simple to understand. I think in this regard, just we have a small 2, 3 questions in mind before we go through our depositories, the officers who are present with us, Mr. Manish Sawant from NSDL, and also we have Vinay Madan, and also this Rajesh Jatekar, then from CDSL. We seek the help of the depositories officers teams when even more depth and clarifications are required. Since you also mentioned to us that the SEBI has considered our request and also already thought of our difficulties and granted us limited extensions, whatever the level wise, 6 levels are already given each level what is the difficulty, and to the proportionate that the extensions for timelines are also granted. In this background, there are always a sense of, I say, ownership in the sense of, for example, one member is not having any client at all. So should he also go for it? Second, now the member doesn't provide any online platform of trading. Now, clients may be there. There are only hardly 10, 15 clients where he do calling and do the trading. So in that context also, should it be required? So these are all simple questions, but more tensionous, I don't say tensionous, but a kind of little doubts
There is
we
a little
entertain that why it is required.
curiosity in the
So in
mind
this
of people
context,
whether to apply or not.
absolutely. So can you please also run us through your answers on these?
Yeah.
Should it be
So
made mandatory?
the answer is already there in the SEBI circular's first point of action. Every broker has to list down the digital platforms. Now, if he does not have a digital platform in itself, that is, he does not have a EKYC platform and he is not providing internet trading facility,
Mhm.
then he will say that I don't have any digital platform which is required to be given under this circular. And therefore, the entire thing will not apply to those people.
I think great answer. I think this is what we are looking for,
Hmm.
a kind of relief. When a
Hmm.
member is not having any platform other than his simple mandated website by SEBI, then those digital platforms need not be created. That is what is the clarity you are giving. Fair enough. Fair enough. I think that is where our impression is we are required to create trading platforms and also digital platforms, whatever that other than my website, to compliance of it. So that first clarity has come. I think then we have one more query received. Why this is internal audit, additional cost burden for audit of IAAP. Is this internal audit and additional cost will come on this, or
Yes,
how you want to
yes.
respond?
It will be a separate audit.
It is a separate audit. Okay.
Yeah.
So if I don't have the trading platform application
Then
or other
you don't
digital
need
platforms, I
to
don't need.
submit the audit report. I believe MIS will come up with the requirement of giving a declaration and then it will close.
Oh, super. So what now you're mentioning is, no, we have all 66, around 70 questions we received, which we shared to you. I believe all those were answered. In case any member believes today or the question is not yet answered by us, please use the chat box in YouTube and please post your questions so that no Ravi can answer. Even depository officers teams are here who can members I request to utilize this opportunity to take clarity. I think 90% of our complex issues are resolved already because we don't need to maintain any compliance if I don't have the platform at all, trading platform, etc. And the proprietary trading, I don't have a need to do anything other than the mandated website. So whatever the cost of additional auditor, whatever that is required, that is going to come upon us if I'm having a trading platform, the digital platforms. So with this, I think I'll just check on the website, on the YouTube, if any questions are there. I think any comments from CDSL, Vinay, can you come in for any remarks from your side? Any comments from your side?
No, I think first of all, thanks to Mr. Ravi Ramaiya. Uh, so no additional points from my side. In fact, I was going through some of the acts, and at one place I saw that even if there are no clients onboarded, even then this is required because later on you might have onboarding. So this is one just clarity I thought I'll provide because I read it somewhere in the law. Maybe I'll check the specific section, but maybe Mr. Ravi Ramaiya can confirm this.
Sir, my in fact understanding came from giving the list of digital platform. Now, if someone has none, what will he give? So that was the logic that I tried to draw to answer that question. Maybe now this is a very evolving area. Maybe you have given a better perspective. Things may change. My understanding may be incorrect because I have also I am also having a limited reading, and this is the first time I have
Right.
got an exposure or an opportunity to deal with such kind of a subject. So
Right.
all of
No, no.
us
So
we will keep on
my
learning
comment was
together.
my
Yeah.
comment was not on digital platform. My
Mm.
comment was that the digital platforms are there, but
Mm.
there hasn't been any onboarding done, so there are no customers as yet.
Mm.
So in that case, so I was referring to that point.
Fine, fine.
Yeah, yeah. So naturally, if there's no digital platform, that's a separate question which you have already
Mostly
clarified.
the prop kind of brokers or those who do only for close family members,
Yeah, yeah.
they will not have any, even EKYC,
Hmm.
who do only proprietary trading. So for them, I don't think this will apply, but still let us see how things evolve.
Sure, sure.
Yeah.
I think, thanks, Vinay. May I now request Manish Sawant from NSDL to come in for any comments from your side?
Yeah, hello. Am I audible?
Yeah.
Okay. I just have one question with respect to the PDF, which is the Microsoft document which sir just showed us. So in our platform, we have already have a lot of old PDF documents that are published on the website since 1996. So how do we manage these kind of old PDFs? In fact, some of the PDFs are also digitally signed. So how can these documents be made accessible? That would be my question.
So if we do the literal interpretation of the requirements, those will have to be redone. And that is why the requirement of audit, observations, rectification, and then final go ahead. So it may be required to be written. Now, if SEBI comes up with some kind of a further clarification, then maybe we can take that as an exception. But as of now, to my limited understanding, it appears that everything has to be written.
Okay, got it. Thank you.
Thanks, Manish. I think, Ravi, there are more issues on to suggest the names of IAAP auditors. Are there any scarcity? Is there any scarcity in the sense, or is it something like members are afraid of the?
Sure, I have not tried to search, but I believe APMI, which is the um, body for portfolio managers like ANMI, they have already had some sessions with IAPP empaneled auditors. So maybe you can get in touch with them, or if you require, I will also try and search. But right now, I do not have the information.
Great. And we have another question received that we have internet trading facility through BSE WOW Exchange hosted facility. So we need to apply this circular. So I think your answer is already there. We have to apply because if you have a trading facility, then you have to list that as a digital platform,
It
right?
applies to MIIs also, no? So BOW will have to be made compliant by BSE itself.
BSE, and my member is having a trading facility through WOW
So BOW
BSE.
is a platform given by BSE
Huh.
which a member uses.
Yeah.
So member does not even have the authority to change the code of that software. So definitely that compliance will have to be done by BSE because they are giving BOW facility.
So for him, what is the compliance there? Should he need to
Nothing.
declare that it is
For him, he does not have any own platform. So he
okay?
will have to give a little more clarification that I am using BSE platform, so BSE is required to comply.
Perfect. So from his side, it is only
Yeah,
declaration
so
part
don't
that is there.
write zero in digital platform. Simply write that we are using BOW and which is an internet trading platform given by BSE to its brokers. And therefore, all necessary changes to the application and compliance with regards to this circular will have to be done by BSE.
Great. I think we have another query on the YouTube chart. Can you please confirm what is the exact requirement to be implemented in EKYC and EKYC re-KYC portals? Can
Yeah.
you respond?
So, see, broadly, it will have to cover three types to my limited understanding. Of course, we have to cover all kinds of disabilities, but if we have covered these three, that is visually impaired and those who are not able to hear or speak. Those two things, if we are able to cover first, I think that should be very helpful. And along with the, so for the people who cannot see, things will have to be in a sequential order where machines can read and take the response from those people.
Mhm.
So voice recognition is going to be a very important part of it, not just converting what is there in my website into voice, but accepting voice commands from a person who is visually impaired will also have to be a part of it. Or you can have assisted KYC done, where some person, see, they have given that there has to be some human assistance also. So maybe if someone is visually impaired, you have a recorded line, you say, sir, आपका इसमें ये apply होता है क्या? He says no, then you mark no. And but you keep the entire conversation recorded along with the flow of KYC. I think that should also be a way of compliance. See, ultimately, no one should be felt left out. That is
Understood.
the main purpose of this requirement. And it is, I will again give the same disclaimer that it is an evolving subject. All of us will have to read, understand, and go ahead. So, as of now, to the limited knowledge that I have, I believe this is fine. With regards to hearing and voice impaired people, you will have those sign language videos running at the bottom along with caption. Caption again may be required in multiple languages because if we have seen that accessibility, if you remember, it says languages, cultures, and so many other things. So that
True. True.
clarification will also have to be sought from SEBI that whether that captioning has to be in all languages or multiple languages or no. But captioning and sign language should suffice to my understanding.
Great. Thank you. This is another query that can is any employee of an organization is also a certified IAAP. Can he perform the audit of his as well as other organizations?
I think he should not, and other organization also, because if he is in employment, he should not be able to do independent activities.
I think there will be a conflict of interest even to do his own
Yeah.
organization.
Yes.
He being an employee, if he's a
Yes.
consultant, that matter different.
Yes. Yes.
So he cannot even may not be allowed to do for other organization being an employee of your company.
Hmm.
Uh, that depends on the terms of the employment, but
Yeah.
that we. I think please share definition of digital platform. I think that already you covered
Hmm.
the definition of digital platform. Right now we will go to the how can we implement the circular of placing orders in mobile or web.
Sir, just for clarity, we will say digital platform means whatever is accessible digitally by end customers is a digital platform. So your CTCL terminal may not be a digital platform, but your IBT is a digital platform. Your ledger which goes to the client on website and mobile app is a digital platform through which it is accessed. But you giving it to your sub-brokers is not a digital platform in this. So end customer is important.
So public view, whatever is being displayed for public view should be treated
Yeah,
as a
yeah. That is a simple litmus test that should be applied.
great. How can mentally disabled people can enter into any trade or agreement?
That I
This is
have covered, sir. Maybe if someone with
this is
neural
all
disorder, less
I know.
earning, if it is not falling under the permissible contract act, then it is surely not applicable. But we will have to study, not whether whether a particular disability means lunacy or not in law. That will have to be checked.
True, true, true.
So someone may be having slow learning. Now that person, whether he is eligible to contract or not, that is, I am not at least a person who will be able to comment. It will have to be checked.
Medically
Medically also, and what in law, I also, that also we will have to research
absolutely.
and find.
I understand. So do we need to update our website documents to easily accessible to person with disability? I think already you spoke
Yeah,
about that
100% it has to be done.
that or back office softwares of web live servers provided to clients are covered in it. So you already said if it is a public view, it should be done. Otherwise, if it
Yes.
is only shared to sub-broker, it is not. Then extension of timelines and update of reporting authority for IAS and RAS is the subject is extension to be specific to those all RE uh,
Extension is applicable to all. All.
to all. If a RE has the following, what all should be compliant? Website, IBT, internet-based timing, STW, mobile trading, back office, portfolio, EKYC, HRMS for employees. I think all are yes.
HRMS may not be covered because it is internal to the organization. What is the last one you said?
That is the HRMS for employees. I think you said that it is not
No,
necessary.
next one after HRMS, what did
The
you
one
say?
is HRM for employees.
Okay, so that may
HRMS
not
for
be
employees.
required, but rest of the things, the endpoint is customer, so it will have to be compliant.
So already the question is if a RE has the following, means if he is having all these, then he has to be compliant except the HRMS, right? Website, IBT and that. Online KYC is taken from third party vendor, then should we comply?
That third party vendor should ensure compliance and you will have to use the services only of the vendors who are compliant.
Then can we deny?
Acha, in this you can have one more hybrid model. Let me share with this. See,
Okay,
you have some EKYC vendor, let us say he is not in a position to do all this kind of, because these are Herculean tasks and he is not in a position to do all this. You can have multiple EKYC vendors simultaneously.
okay,
And even if one is compliant, it will be good enough because see, you will route the journey of client acquisition to that platform. So
agree.
you may have two or three platforms also for eKYC, and one of which should be this one. And the moment the customer says, I am a disabled person, automatically he should be moved to that platform.
Understood. I think there is another question like, can we deny? Uh, can we deny to open account of physical disabled person as per internal policy?
No.
I think it is against to the law. You cannot deny.
Yeah, it is a very clear direction in the law. You may reject for any other reason, but not for this reason.
Hello.
Like, yeah, someone may also be disabled and still SEBI debarred also. So there, your ground is not his disability. Because he is SEBI debarred, I am not
True.
trading.
So I
So
cannot.
otherwise, we should not deprive these people from the access.
If any person
See,
is coming to me to
SEBI
open
can,
account,
one more thought which runs my mind is, see, SEBI can make it mandatory in stages. Maybe first stage, they may mandate bigger brokers who have the wherewithal, and then let it percolate to others once the systems have stabilized, because there is going to be too much to and fro also in this. Like if you see the latest requirements which have been recently implemented, be it enhanced supervision, be it allocation, segregation, so much to and fro, clarificatory circulars come. So
true.
let one sample of brokers get those implementation, then issue a master circular giving all requirement, and then you can mandate. So that is one way in which you can avoid to and fro of all entities and do it only with some select entity.
Agreed. I think more so is the theme is that the purpose of the object is that if anyone is coming to open account with us, we cannot say that I don't have software which can accommodate. Therefore, I decline accepting your this thing. By even physical mode or whatever the mode we should accept. There is a underlying. So in
Yes.
one of the APMI session, it was mandated by IAAP auditor that it will cover specific website, PDF, email, etc. Even if no internet trading, client login, this is applicable. We need proper guidance. Can you comment
Sir,
on this?
I said I may be wrong. Please seek a clarification from SEBI.
Okay.
Yeah.
So can the website have a specific and limited pages, content for disabled clients, and they can be compliant instead of the whole website? I think that is the link you are giving always, right? On the website.
Sir, no. This question is little different. Let us say you have a section for research reports.
Okay.
Now that is not compliant, but basic website like company name and what they provide and all that, if that is compliant, whether it will suffice or no, to my understanding, the answer is no. Everything will
Okay.
have to be in that manner. You may choose to, that is also my personal view, not do certain things which are not important from today onwards till later. Like if a research report 10 years old, don't sit and convert that. But at least
Understood.
going forward, whatever research reports are coming, sir, and it is very simple. See, I have shown that document also. You will
True.
prepare it in Word and generate a PDF. Once you follow those Microsoft guidelines, all your documents will automatically be compliant with the requirement.
Fair enough. I think these are all the now the tools are available, and even the software is enabled to have the kind of
Hmm.
voice recording, etc. The PDFs.
Yeah. Yeah.
Now we have another can the website specific and limited pages content for disabled clients, and they can be compliant instead of whole website that you answered. We have IBT EXE based. So it is applicable for us also?
Yes.
Absolutely yes. Please share IAAP auditor details. I think you should now do some homework on this.
I will
for
do it. I
the
missed
for
out on
the
that. Sir. Actually, I should have come prepared. Yes.
I think this is there are many questions. I think the subject itself is so probably members have got some relaxation because of the extensions we received from SEBI just now.
So
Uh,
maybe the attendance also is less because of
no,
extension.
it crossed already 500 plus. So
Is it?
so it is nice. I think any complex situations, since there are interpretational issues still revolving around us to take a conclusive interpretation, we try to
So
reach out
those
to
are
the
actually, borderline issues. But see, primary guideline is very clear and we should start working.
true.
Borderline issues, whether we can have all pages or some pages, at least let us start with some pages so we will know how convenient or difficult it is to apply it everywhere.
But think from the perspective of member who is interested to do all this, then whom he should approach for all this compliance, etc. Is it so easy for them to
So
handle
engage the
internally?
auditor for implementation also. That will be a better idea.
Is it going to add some cost to members like
It will add a
nice?
cost. It may add even substantial cost. Now,
Oh,
substantial is a very subjective term. For some
true,
people, 20 lakhs may be
true.
subjective. For some people, 5 lakhs may be subjectively large.
Oh,
So depends, but I think it is going to be a substantial cost burden for one-time rectification, and same applied everywhere, sir. If you see the terms of reference for cyber security, everybody has incurred costs. But now,
true,
if we see how safe the entire market has become,
true.
so things will fall in place. Initially, there will be cost, then it will be routine maintenance.
So what about internet banking payment gateways for adding funds? Will every bank require to implement accessibility?
Sir, not just bank, all organizations. Even Airtel and Vodafone and Reliance Jio will also have to fall in place with this requirement.
Oh. So I think many questions are there. So even to get the interpretational clarity on some of the 2, 3 issues which you also felt there is a requirement to do a deep dive or the deep detail. So we will request you and the depositories also. We have not brought in exchanges now because of some relaxed mood. We are all happy with 1 month or proportionate extensions what we got. We will seek leave from this webinar as of now, unless depositories. I think Vinay and Manish, you wanted to come in. Otherwise, Ravi, can we close the webinar?
Yeah, I am very thankful to ANMI for
Uh,
allowing this opportunity. It gives me
no,
one more
it is from my
motivation
side, I
to
should
read
say.
very thoroughly. See,
Yes, yes.
otherwise I would have just read SEBI Circular. Because I had to have this discussion, no, I went on searching so many things, including Microsoft document, how it is to be done. So many things. I got an opportunity to learn. Thank you very much, ANMI,
I
for
know, I know.
engaging
This
me for such
each
seminars.
day for any expert, it is a learning, and you're keeping always your hands on the learning methods. Like how you shared, even the software technique today is very helpful to us and to all the members. And I think before I close, I think I should take this only last question, which I though my member may feel that uh, we only have the website, not mobile application. Then also is required. Already you answered. It is not required. For individual research analysts, can you please guide? I think research analysts, what is the issue?
So research analyst will have his website. They will
I see.
host their research reports there.
Oh,
So one is the website will have to be done in that manner. Second is they will have EKYC platform also. So that will have to be compliant, and all the reports that are circulated to customers, those will also have to be in the format which is required.
great. As we are sending contact notes to other details to the client. All these documents are to comply with the act and how it will be identified. I don't think this is covered under the act under the.
Sir, contract note you cannot cover because that document per se, if we see, it is having too many tables. And then sequence of reading also you will have to start from top left. 90% of the time it is consistent, same content, so that we will have to skip. So I don't know how, because if you send it in PDF, PDF is going to read from top left to right bottom, including authorized signatory.
True, true.
So I
But
don't know
having
how to.
entertained, Ravi, I have a small doubt. Having entertained a person, challenged a person, how can I send contract note
Sure,
without
you can
the
send
software?
one is the full contract note to ensure compliance with SCRA requirements. And
Must be
along with that, you should send another document which will have same transactions but in a readable format, which will be more convenient.
with
Because
voice.
otherwise, if you ask someone to read contract note, 90% of the content is not going to be relevant. It will start from company's name, name of the compliance officer, phone number, PAN number, a GST number, so many things, including title of table, everything will have to be read. Then at the bottom, you have so many conditions, 6 conditions, which are there in small font in the bottom left. Then on the right side, you will have authorized signatory name, this, that, whatever. So all this is irrelevant content. So you may have an alternative document along with a contract note which will be readable for the convenience. So you will be doing both. Actually, you will be meeting the purpose as well as you will be complying with sending contract note.
So, Ravi, I think two levels this question we can take. One is we are answering to the member that all contract notes uh, fall under the compliance,
Yeah, you have to send the
right?
contract note. Answer is
Done.
if it is
Yes.
not readable for someone who is visually impaired, should I send
Then
or no? Answer
then
is you should send.
send. And second is now how that enablement can happen is by using the technology. That's
Another
what.
document also you can use which will be compliant with the guidelines of the act and the rules thereunder, which will be
As
used by the person for reading what transactions he has to.
reading. So it is
Reading
compliance
means
is there.
he will listen. See, software will read and he will listen.
You will listen.
It is
That's
problem is with visually impaired, sir. Here, if someone is hearing impaired, no, you don't have any problem. You will read the contract note.
true, true.
Yeah.
No, for individual research also you said we have IBT and EXE based and not based. It is applicable to us. You said already yes. Uh, Fair enough. Then we will close here. Like I'm thankful to. With the permission, I'm closing Ravi. My depositories officers Vinay and Manish. Thanks for joining us at last minute notice and thanks for honoring the request and giving your views on the topic. And I special thanks to Ravi, who has done a lot for our members. And he is, of course, a known name among all of us. For any compliance matter or any issue, we approach him and his advices 99% accepted in all regulatory forums as well, because the interpretations never gone beyond of excesses. So with this, Ravi, special thanks to you, and we expect you keep coming to us and clarify our members' queries in the same way how you are helping us. And I thank even my national president, CA K. Suresh sir, for spending his time, sparing his time, coming on this webinar for giving a welcoming no address. And also his initiative to first take on this has helped us to do this webinar. And all these questions or queries received from members exceeded 100. So in case I request the members, some of the questions, if you feel, according to me, 90% already answered. And now with this webinar, we answered all 100%. Still, you believe that there are some queries in your mind, you please write to us. We will take back to Ravi, or the required help will be rendered to you. With this, thanks Ravi and Vinay and Manish. Thanks for Suresh sir. Thank you very much. I close
Thank you,
this.
sir. Thank you very much.
Thanks,
Thank you.
everyone.
Thank
Thank
you.
you.
Thank you. Thank you.